I did my estate planning in another state. Do I need to update it now that I've moved to Georgia? Hi, I'm estate planning and probate attorney Zach Beck with Peach State Wills and Trust here in Lawrenceville, Georgia, and we'll answer that question in today's video. So, you did your estate plan in another state, and now you've moved to Georgia. Do you need to update it? So, under the full faith and credit clause of the U.S. Constitution, for you history buffs out there, that's Article 4, Section 1, states are required to honor and give full faith and credit to, quote, the public acts, records, and judicial proceedings of every other state. So, as it pertains to estate planning, what that means is, for the most part, estate planning documents executed in one state will be honored in another. There are a few exceptions. Importantly, Georgia law provides, for instance, that an out-of-state will must be valid under the laws of Georgia. So that would exclude things like handwritten, unwitnessed wills, also called holographic wills, that may be valid in other states. So, strictly speaking, most of the time, you don't quote-unquote need to update your estate plan just because you've moved to Georgia in order to be valid, provided that your out-of-state plan included the foundational estate planning documents, so a will of a trust, a healthcare directive, and a financial power of attorney. The real question then becomes, well, should you update your estate plan now that you moved to Georgia? The answer to that question is often yes. While your foreign documents may be valid here, they were written and optimized for that other state laws and not Georgia's. For wills, that may mean they lack important things that we do under Georgia law, like waivers of bond, inventory, and annual returns that can make the administration of your estate easier and more efficient. For healthcare directives and medical powers of attorney, doctors and other medical staff may be less familiar with another state's form, which can add unneeded and unwanted complexity and stress to having your wishes carried out. For financial powers of attorney, unless that document was executed after July 1st, 2017, in a state that adopted the Uniform Power of Attorney Act, banks and other institutions here in Georgia may not accept the document, making it difficult and time-consuming to be able to have someone manage your affairs if you're incapacitated. Thus, while it's not strictly required to update your estate plan now that you've moved to Georgia, it's often a good idea to have those documents reviewed and maybe updated when you move between states. For more information about estate planning here in Georgia, check out our YouTube channel, visit us online at peachstatewills.com, or give us a call at 678-344-5342.